Hi, I'm Byron Batres, the founder of EZ-Probate. And thank you for listening to our webinar on how to go through probate for less. I'm here with Gary DiGrazia Sr. from EXP Realty, and we're going to be going through how probate works in California. But before we get started, let me just tell you about myself. I'm a certified financial planner. And like many of you, I have been exactly in the same situation you are, which is presented with probate. And fortunately for myself, as a certified financial planner, I basically knew what to do. I knew everything there was to know about probate from a financial planning and how to avoid it perspective. But actually going through the process is rough no matter which way you slice it. Like yourself, I had to get letters of authority. These are my letters that I got back in 2012. And when I started the company, it was really from this experience. I knew firsthand what it was like to go through probate. I knew firsthand what it was like to deal with family. Typically, if you use an attorney or there's somebody else like a third party involved, there's going to be some real distance between the issues that's going on with the family and versus what's going on with probate. And so through my challenges, which were many, we were able to do probate without an attorney, and I was able to save our family over $10,000 in legal costs, which frankly I didn't have, because very often by the time you are appointed, you've paid for the funeral, you paid for the court fees, you start paying for bills, and before you know it, you're kind of out of money, because not many of us can afford 10, 15, $20,000 out of pocket in any one particular month. So saving on legal fees is really, really important. But we really don't talk about necessarily the stuff because remember, there's a person involved. In our family, that was Mary Ellen. This was the person who entrusted me to be the executor, my wife's grandmother. And obviously, we had lots of um, family outings and events at her house. So it's more than just a house. It's more than just an asset. You're really dealing with really the ending of someone's life. That's somebody that was very important with you. And the one thing that happens with probate often is that the probate process is one thing, but dealing with family is really another. And I had lots of challenges. There is my wife's father, Peter, and frankly, he challenged me at every step of the way. I petitioned the court, he challenged. I presented the will, he challenged. I wanted to do an inventory, he challenged that. I even got sued. All of that I was able to navigate all without an attorney, but really it was very, very difficult. And this actually was his challenge. Sometimes people get really concerned about if someone's going to challenge. Well, I don't know if you're going to take the time to read all this, but he basically wrote a crazy letter to the court, and it was actually not that hard to discard his challenge. So at Easy Probate, we have a saying that probate is easy. That is the forms, the court process, but the family can be hard. Our job is to make the probate process as easy as possible for you because there's no need to add extra cost and frustration to that. And typically that comes at the form of an attorney. Attorneys are slow, attorneys are expensive, and oftentimes they do not respond in a timely manner for you to get your hearing court case done, especially if there's any urgency in selling assets. But we're here to talk about probate, so let's move forward. All right, so what is probate? Probate is the court supervised process of transferring assets after somebody's passed away to the lawful heirs. And you also have to make sure all the affairs are ended, which would be paying taxes, doing all that stuff. And every single person that dies with assets in their single name that does not automatically transfer to somebody else, those assets have to go through probate. So what are some common examples of assets that can transfer to somebody else? That would be joint ownership rights or survival, any kind of contracts. Think of like life insurance, technically is a contract, where there's a beneficiary involved, and essentially retirement assets. Those pass on to a beneficiary. And mind that a beneficiary has to be a real person that is alive at the time of the person who passed away. So you can't have somebody who predeceased be a valid beneficiary. They would essentially get skipped. And then essentially all these assets that require a court order is really probate, is a probate asset because you can't change the title without the court authorizing you to change the title. And so probate really means to prove. If there is a will, you have to prove that it's valid. This is a very common misconception. Many people think that if there's a will, you don't need probate. No, the opposite is true. You have to prove the will valid. Otherwise, I could show up to Gary's bank with a fake will and say, give me all the money, right? And so a court order is required in order to change the title, even if there's a will. If there is no will, you prove who the heirs are, and that's typically through what's called intestate succession. That is just simply who are the next of kin who are going to be, by law, the people who inherit. Now, how long does probate take? So in California, there are several steps. I kind of broke them out here. First step is to petition the court. Now, from the day that you file your court paperwork, typically about a month later, sometimes 2 months, but typically 30 to 40 days, you're going to get a hearing date. After the hearing date, assuming everything goes well, then you would get the authority to act on the estate. Act on the estate, you have the authority from the court to be the personal representative, an executor if there's a will, and an administrator if there is no will. Now, oftentimes there is assets that need to be sold. As soon as you have the authority from the court, you can sell assets. And in California, to sell real estate, you're going to need what's called a notice of proposed action, assuming you have full authority with no limitation from the court, which is the most common authority granted. You would be able to sell property, and all you have to do is notify the court and everybody involved of your proposed action. If somebody wants to object, again, they have to do a actual objection, and they would have to prove a reason why you can't do that in court. Most people would consent, and if they don't do anything in 30 days, it's considered a consent. So typically you'll take about a month after your letters of authority to be able to sell real estate in California, assuming everybody consents. If everybody consents, it can even be quicker because all the consents would then be filed. And in theory, you could essentially close real estate the day after you get your letters of authority. Typically within 3 months after you're appointed, you have to file an inventory. That's just the assets that are in the estate. What is the starting point of the estate? When you petition the court, you don't need to know exactly what's in the estate. What you do need to know is a rough idea of what's in the estate. And then 3 months after you're appointed, you would then present to the court your actual findings. Because until you're appointed, there's really no way to know what's in the estate. You have no authority to ask the bank exactly what's in the estate. In fact, most people won't tell you anything unless you have access to statements or communication that's coming to the deceased house. You really won't know what's in the estate. So that's why you get so much time. And then basically during the process, you have to pay creditors, file taxes, close all the legal affairs for the person. And that's just going to go on as long as it needs to go on, depending on the situation. And most people are able to do this well within 6 months. Very often there might be extraordinary circumstances where it may prolong it. We have a case that's going on 4 years. Why is it taking so long? Well, the asset is a lawsuit. So until that lawsuit settles, the probate case won't end because the probate has to receive the settlement of the lawsuit. And so that just takes a long time. So depending on what's in the estate, that can prolong it. And then once you're ready to close, you've done all the things you're supposed to do, which the court will tell you what you're supposed to do. You petition the court for the final distribution. Now, this can't be done until 4 months have passed from your letters of authority. The reason it's 4 months is that's the creditor claim period. So essentially there are creditors you're going to know of. You know, there's a mortgage, they send you a statement, there's a credit score, a credit report, and you know, it's clear as day who the creditor is. But if you don't know a creditor exists, how would you even contact them or try to settle with them? And that's what the creditor claim period is for, is that because probate is public, prior to your hearing date, a public notice, which is a legal ad in the paper, would have had to be posted. creditors have the ability to come to you and say, hey, I'm a creditor. Once you deal with all those creditors and or the 4 months have passed, then essentially no more creditors are allowed to come forward, because there has to be a line in the sand that says, all right, you are now ready to present to the court your distribution plan, which is why we started in this section. Once that 4 months has passed, you present to the court your plan of distribution. And essentially, you tell the court what you started with, what income and or other assets have been received, what expenses, creditors you've paid, what's left over, and who is that going to go to. There will be a hearing. So again, typical process, you petition the court, roughly 30 to 40 days afterwards, there'll be a hearing. Assuming everything goes well, you get the order for final distribution. Once you have the order for final distribution, then you distribute the assets. Everybody gets whatever they're supposed to get. They will sign what's called a receipt and release, basically saying, I received what I was supposed to get, and I discharge the executor or administrator for any further duties. And then you basically tell the court that you did what you're supposed to do, and you present to the court all those receipts and release, and then you're discharged. And that process, there is no hearing. You just send all the paperwork to the court and it's all done. Obviously, if somebody complains and or says, hey, I didn't get what I was supposed to get, well, there's likely to be another hearing. So generally speaking, the last process takes less than a month, which is the actual closing of the estate, getting the discharge paperwork. But generally speaking, in California, it can take anywhere between 3 to 25 months after you've been appointed. The fastest it can be is 3 months after you're appointed. I'm sorry, 4 months after you're appointed because of the creditor claim period. And then 25 months, again, just throwing a number out there of what is typical of longer normal cases. I would say the majority of our cases are settled within 6 months. Again, the main issues with how long it takes are creditor claims and essentially the complexity of the assets. If you have a complex asset that needs to be dissolved, and attorneys are required to do whatever that asset requires, and that obviously that can prolong. There's actually a very famous estate, Frank Sinatra, because of his likeness, his estate will never end. So typically famous people will always have a probate case that never ends because they're able to license their image, their themselves, if you will. Unlike royalties are an asset, but the visual person replica is an asset that can only be paid to the deceased, therefore the estate. All right, so who needs to be notified in probate? Well, essentially every person that is a next of kin or that would inherit if there is no will. So next of kin is a very specific priority. Typically it is the spouse, then children. If no spouse and children, then parents, brothers, aunts and uncles, and distant relatives from there. So there's like kind of a priority. If there is a will, any person who is listed in the will needs to be notified. That could be the successor executor, the charities are involved, anybody who's listed in the will. Even if no one is listed, if someone is a next of kin, they do not inherit in the will, they still have to be notified. Any known creditors would have to be notified. Again, this is of the petition process, and any person who lists themselves as an interested party. Probate is public. Anybody can raise their hand and say, I want to be notified. So if you do get a special notice for anybody as an interested party, you just have to notify them. And that is throughout the probate process. For those who don't inherit if there's a will, but are a next of kin, once the initial petition process is over, you don't have to deal with them anymore. So only if there's a will, you do have to notify all the next of kin, regardless if they inherit. After the will is proven valid, they're not really an interested party because they're not going to inherit. And then essentially you would place an ad in the local newspaper for any unknown heirs, unknown creditors. That way everybody has an opportunity to be notified. All right, so again, we talked about who inherits. If there is a will, the will dictates who inherits. If there is no will, then state law dictates who inherits. Again, that's going to be surviving spouse, children. If no spouse and no children, parents. And then if no parents, siblings. If no siblings, aunts and uncles, and so on. Now, what specific assets go through probate? We mentioned this earlier. Any asset owned by the person who died in their single name will go through probate. However, there are some exceptions. So again, any assets in their single name. What are some examples? If you own a bank account in, my name, Byron Batres, I own a bank account. If it's in my name, it'll be a probate asset. If there are deeds, like a vehicle, if there's real estate, and title to the deceased, all those things would then go through probate. Now, personal property is very interesting because personal property is the stuff everybody owns. I always give the example of like the golf clubs in my dad's house. If my dad wanted me right now to have the golf clubs, he would just say, "Hey, Byron, go take my golf clubs." There's no title to golf clubs. So how would you prove that who's supposed to go to what? The stuff in the house typically is deemed to be owned by the person who owns the house. So however the house goes, all the stuff in the house will go with it, unless it's specifically bequeathed in the will. Bequeath is a term that just means I give this specific asset to my son. So for example, if my dad really wanted me to have his golf clubs, he would put those in the will and says Byron gets my golf clubs. Then it's clear who gets what. If it's not clear who gets what, it'll go through whoever owns the title of the house. So if there's a house and the will says Byron gets the house, then Byron gets all the assets in the house. So that's something to remember, especially if there's actual valuable items like jewelry, gold. We've had a case where there was gold that was supposed to go to somebody else, but it's not clear. Whoever got the house will get the gold. So again, personal property will follow the title of the house if there is one. Any income assets that the person owns, think of income assets like royalties. So if there's mineral rights, or they were an author or a singer, the rights of future income of theirs will then go through probate. If there's a safety deposit box, obviously that's something that would transfer. Side note, oftentimes the will is in the safety deposit box. So how do you get to the safety deposit box if you don't have the will? Well, there is a petition to basically ask the court to order the bank to show you the safety deposit box. And so in California, I think you can just do that without an affidavit, but oftentimes there is a petition that you can ask the court to open the safety deposit box. Now, common examples of things that don't go through probate. So again, any asset that's owned jointly with an automatic transfer, like a rights of survivor, will go to somebody else. Now note the rights of survivor. So typically there are two types of joint tenancies. There is the joint tenancy in common, and then joint tenancy by entirety, also called with rights of survivor. A joint tenancy by common is two people own real estate and they own their own what's called undivided section. Again, think of a house. You can't put a house, chop it in the half of it and say you get one half, you get the other half. It comes as a whole house. So whatever percentage somebody owns in the house, it's called an undivided ownership. And so I may only own a third of the house, but essentially I have access to the entire house. Same with a deed. So if there's a joint ownership in common, that person's share of the property will go through probate. If there's joint tenancy by entirety, also known as rights of survivor, then the surviving owner gets the whole house. So essentially anything that is automatically transferred, joint tenancy by survivor, also called by entirety, bypasses probate. So any asset we mentioned with a designated beneficiary will bypass probate. Again, that's IRAs, life insurance, those kind of assets bypass probate. Again, it has to be a valid beneficiary, which simply means a real person who is alive at the time of death. They are alive at the time of the IRA owner passed away. And then essentially any assets that transfer what's called payable or transfer on death. So if you own a brokerage account or a bank account and you want to transfer that asset without probate, you can designate a transfer on death or a payable on death, and it acts like a beneficiary. Upon my death, this account goes to somebody else. Very often you can do that with deeds as well. That's essentially what's called a transfer on death deed, or oftentimes called a ladybird deed. Now, the last type of asset that can transfer without probate is something that's in a trust. So if the asset is owned in the trust, it does not require a court order. It's already owned by the trust. The trust exists beyond the death of the person who creates it, therefore no probate. Now, we often get the question is, do I really need an attorney? Well, simple answer is no. In California, there is no requirement of an attorney by law for any type of probate case. So you can definitely do this on your own without an attorney. Now, there are oftentimes very good instances where you should have an attorney. Typically, if there's going to be a contest, if the estate is being contested, we highly recommend you getting an attorney. Now, some contests are super easy to kind of parry. Other contests, it's going to be a legal mess, and attorneys are going to be required. If you absolutely need full authority and absolutely don't want to have a bond, I'll explain that in a second, an attorney is highly recommended. In California, it is the judge's discretion on whether or not they give full authority and whether or not they require a bond. Even if there's a will that says there is no bond, I have seen judges say, you don't have an attorney, I'm going to issue a bond. What is a bond? A bond is essentially insurance policy against the errors and omissions and or outright misconduct of the personal representative. And typically it costs, probably a few $100s for every $100,000 of value that the bond is required. And the bond will be required at the full estimated value of the estate. And if you do the inventory and you find out that the estate is worth more, you got to get a bond additionally to cover that extra. It doesn't have to be super expensive. It kind of depends on your credit score, but think of a bond as an insurance policy that is required. I mentioned full authority. What is full authority? Full authority is very simple in California. If you're issued full authority, you can act completely without any approval from the court before you do anything. So we talked about real estate earlier. If you're going to sell real estate, highly, highly, highly beneficial to have full authority over limited authority. Because if you have limited authority, you're going to have to petition the court for every major decision. What's a major decision? Selling assets. Obviously, if you pay bills, no big deal. But if you're going to structurally change the assets of the estate, you're going to petition the court. And that starts that whole cycle. Petition the court, 30 to 40 days later, there's a hearing and so on, right? So it just delays the process. And we would be the first to tell you if you're going to need an upgrade. So if an attorney is required, we would essentially tell you that. So we would be the first to review your case and tell you upfront which types of processes that would work well for you, and also whether or not you should be the person in charge or if you should have an attorney to guide you through that. So at EZ-Probate, we also have an attorney plan. We'll discuss our options in a bit, but we make it very easy. We give you the ability to choose how much help you want from us. If you want very little help, well, we can offer you very little help and obviously charge you very little for that. If you want to do nothing, well, then we have a plan where you basically do nothing and the attorney does most of it. Now let's talk about costs. How much does probate cost? So typically legal fees throughout the country range from $3,000 to $10,000 for simple probate. Some attorneys are by the hour, so they're going to charge you, $300 to $500 per hour. And then some places like California, you're allowed to charge a percentage of the estate value. So it kind of depends on the estate value of what the fee is going to be. Court fees range in the United States somewhere between $1 to $1,200. In California, it's pretty standardized. It's $435 for each petition. Petition the court to start probate, petition the court to end probate, 2 petitions, each of $435. And then, of course, there's going to be the public notice. This is going to be probably the wildest variable because it depends on the county that you're in and the city that you're in. And throughout the country, some could be as low as $50 to $1,500. In California, again, also very variable. LA County, probably one of the more expensive ones, and some other counties less expensive. So probably somewhere between $200 to maybe $1,000 in California is what the public notice is going to be. So you're typically looking at cost between $4,000 to $25,000 for the normal, simple probate cases. Forget anything complicated. This is just to do the paperwork. So now let's go through what types of cases, types of probate you have in California. So if there is real estate less than 55,425 as of 2021, you can do a transfer via an affidavit. You don't really have a court process in what we think of as court, as in there's no hearing, but you do have to file some paperwork with the court, and you get an order to transfer the property. Note that the total estate value cannot be greater than 166,250. So again, if the real estate is under 55,425 and the total value of the estate is less than 166,250, this affidavit process would work. If there is less than 166,250, you have what's called the succession of real property. This is what we would call summary administration, where you basically only deal with court once. The estate is so small, the courts really don't want anything to do with it. And they're like, well, okay, petition the court, tell us what's in there, who's supposed to inherit it. We'll send you an order and you can just transfer it. We don't want to hear from you again. So that's a simple process, or simpler process in California, but the assets, all of them, have to be under 166,250. And obviously they're typically, you would have real estate over 55,425, because if you had real estate less than that, you could do the affidavit process. Then there is full probate. Full probate is any probate greater than, or the assets greater than 166,250. And then the last type of petition available is what's called the spousal petition. This is a special petition only available when there's community property is the only property in the estate. What is community property? It is simply property that is earned and acquired during the marriage or a domestic partner. This is very important. A domestic partner is an official recognized partnership in California. It's almost like getting married. You get a document that says you are a domestic partner. So you either are married or have domestic partnership. All the assets earned, so that'd be income earned, investments purchased prior and gaining are not community property. That would be only anything earned and or acquired during the marriage, domestic partnership, or that is specifically in writing deemed community property. And so essentially all the property earned during the marriage / community property would, / domestic partnership would be a community property. We typically recommend this only when the children of the deceased all come from the same spouse and or domestic partnership, because you really want no objections, and it can be a very, very easy petition to do. But ideally, we want to stress that it's ideally when there's no objections. All right, so now let's talk about your typical probate costs for full probate. So in California, for a typical estate of about $1 million, what do we use that $1 million? Is the average median home value in California is quite high. So let's just use a round number here. Hopefully it's not too ridiculous for everybody. And so an attorney would charge a retainer fee. That's not the total, just a retainer to get started, typically of somewhere between $5,000 to $8,000. The statutory fee, which is what they're allowed to charge in total, would be about $23,000, because again, it's a percentage of the estate. You would have your initial filing petition of $435, your additional closing petition of $435. If there's a will, you got to register with the court. That's about $50. And then if you're going to do a public notice, the LA Times is what often people choose. That'll be $750. So really talking about $26,000, $670 of total costs out of the estate just to do the paperwork if you use an attorney. That's about 2.5% of the value of the estate. And so when you look at the actual part of where the estate the attorney fee is calculated, this is an actual snapshot of a petition that we did of where, what if they had used an attorney, how the attorney fee would be calculated. And I want you to pay attention to these numbers. So the inventory value is $482,500. And then you have any gains. In this case, there was a sale of the house. And so you have the total value of the estate of slightly over $500,000. So in California, The first 100,000 is you charge 4% on that. The next 100,000 you charge 3%, and then between 200,000 and 800,000 you're charging 2%, and that is from the gross value. Mind you, if the debt on the house was most of the value of the house, the attorney would charge this fee. And so in this particular example, if the gain of the house was all that was left over after you sold, the attorney fees would be almost half of the value of the net equity. And so that's an important distinction in California because it's not a net estate, it's a gross calculation. So gross being the total value, not minus any of the debts. So how is EZ-Probate different? Unlike attorneys, we are online. Our system is automated, it is convenient, and it is highly responsive. And so you're going to simply fill out a questionnaire on our website. It's the who, the what, the where, the how much. We're instantly going to provide you a sample of the petition for probate. So you can see that we actually do what we're going to say we're going to do. We're going to show you a sample of the petition that with your information in it. And then once you're ready to move forward, you're going to file and pay. We make ourselves available. You're going to be able to schedule a free consultation. We have hours. We're on the East Coast. We have hours all the way through 9 p.m., which is 6 p.m. on the West Coast. And we are available on the weekends and evenings, like I said. And so you're able to choose the type of program that fits you best. If you want to do it mostly yourself, we have a DIY flat fee, $600. Mind you, none of these prices include court fees, newspaper fees. So the $600 is essentially, we would provide all the paperwork, give you instructions from start to finish until probate is over. So you can do this on your own without an attorney and essentially limited help from us. We have a concierge plan that is $1,250, $1,250. Mind you, that this price is about to go up pretty soon. By the time you see this presentation, it'll be $1,500. And then in this case, we do everything except appear in court. So essentially, we'll prepare we will e-file, we will do the public notice, we will notify everybody who needs to be notified, and you would be essentially just waiting to be told when your hearing is and when to appear. And then if you want to do nothing, the attorney plan is there, and the attorney reviews, files, and appears on your behalf. And so we have those three plans. The attorney plan is $5,000. All these are flat fee until probate is over, and we have payment plans starting as low as $120 a month. So with the same example, if you work with EZ-Probate and use our concierge plan, which is our most popular plan, you would pay a fee to us, about $1,250, same court filing fees, same newspaper fee. But more importantly, we've done all the research and we know which paper is less expensive. So instead of using LA Times, we would find a different paper that costs a little bit less. And then we've saved you tens of thousands of dollars compared to what an attorney would cost. We have the world's greatest online probate team. Frankly, we're the only online probate team out there. And so our team is available, plenty of people available to answer questions. And like I said, we are available on the evenings and weekends. And we're going to be with you until probate is over, no matter what. And again, it's a flat fee. You don't charge by the hour, and there's no add-ons. You pay for the service until probate is over. And that is how EZ-Probate works. All right, now that we've discussed probate in general in California, let's go over some of the specific questions that is often the most important question that we get is, how do you sell real estate within the probate process? So with me today is Gary DiGrazia from EXP Realty. We're going to go basically have a quick conversation on his experience selling probate real estate. So Gary, thank you for joining us. And I'm just kind of curious, what is your background? And if you could just give us a little brief history of your experience with real estate, specifically in probate.
Fantastic. First, Byron, thanks for having me on here. It's been a pleasure working with you in EZ-Probate and helping all these estates. So my background is 46 years in real estate here I'm based out of Northern California. I have a team of a little over 100 agents spread out all over California. And our total business is assisting estates, as you know, when they have real estate that they're going to need to liquidate to help settle the estate. So probate real estate is not like regular real estate. Many agents get into trouble when they're doing a probate property. They don't understand the rules, how to get through, how to keep the estate out of trouble. And what we do is basically work, and you know what we've been doing with cases with EZ-Probate. We're kind of the liaison between the estate, the title company, and EZ-Probate to make sure we have all the documents that we need to close that sale. A lot of states don't understand those rules and regulations for the real estate sale. So in cooperation between us and EZ-Probate, we expedite that for them. And as you know, a lot of the times the cost can be greatly reduced when they're affiliated with both of us, my group and your group together. So we pick up a lot of those charges for the estate. So it's been great. So we're here to make sure the estates get through the probate process if they're selling real estate. Make sure they have all the protections they need in the listing and the sales contract. Maybe they just want to sell the property cash as is. They don't want to go through the MLS process and expose it on the market for everybody. Whatever they need to do. We have a no commission program. We have a fix-up program. We do the trash out on the probate home. We'll liquidate personal property cars for them. So it's a one-stop service that we offer all your clients as the EZ-Probate who may have to sell the estate home.
Yeah, no, that's great. I think what you guys help from our perspective is you take the real estate transaction, all the headaches, all the worries away from our customers, just like we take a lot of the headaches and worries away from the probate process. And then just to recap, just in case it wasn't clear in the presentation, in order to sell real estate, obviously you need the authority from the court to sell. But Gary, because we have such a hot market, one question that we get is, do people have to wait until they get the letters of authority to list the property? Do you find it beneficial for the estates to essentially list the property before the letters of authority, obviously then having a contingent clause in the contract once letters of authority are issued? Or are you finding deals, people are more hesitant to even get into an agreement unless somebody has the letters of authority?
Great question. It's always better to start the process if they're going to be selling the estate property sometime during the probate as soon as possible. We make everything subject to them being approved to be either the administrator in court or the executor. Of course, we're always looking for full authority. That allows them to skip all of the red tape of the court. It allows them to open up the house to any buyer that wants to buy the property, not to the select few that the old traditional probate process requires them to do. So yes, if they started EZ-Probate app today, and 30 days out from now is going to be their PR approval date to be executive administrator, we can actually start in on the property now, get all the preliminary work done, the evaluations done, inspections if we're going to do that, and maybe even line up a buyer for the property so the day they're approved in court, we actually be getting ready to go to closing a week later. And even though the probate process is going to take several more months, we can liquidate that property. Those funds go to the estate bank account, and they have that property that may be vacant. They're worried about vandalism off their table because they got enough to do with the probate process. So yes, as soon as possible if they're going to sell.
Yeah, no, so we've definitely seen that ourselves when people especially have bills and or lenders that are, whether it's pre-foreclosure or possibly even in foreclosure, being able to line up a buyer as soon as possible and then essentially close escrow relatively quickly after letters are issued has been highly successful from our experience as well. So that's great to hear. And in situations where oftentimes within probate, a family member lives in the property and they really need some access to cash or funds before they move out. I know there are inheritance advances, which as a total aside, I caution everybody to do one of those. The interest rates are super, super high. Have you seen buyers essentially be able to negotiate and or facilitate some situations to help somebody move out of the house prior to the transaction?
Yeah, we've kind of covered every which way that could go. So typically, if there's a heir in the property, they're going to need some money to relocate. We can arrange that for them. And we do it privately. We don't use the heir advance services because what they're basically going to do is buy that heir's share. And they're going to probably have a 50% discount. So if they were receiving 50,000 from the closing of the probate when the assets are distributed, they're going to lose 25,000 of that because the company's going to take their position. So what we do is we match up private investors, or we do it ourselves. And if they need $5,000-$10,000 to relocate, we can arrange that for them. Now, if they have tenants in the property, it's a little bit different, especially in California with the tenant laws. There's a special way that you have to handle it. We're just coming out of the pandemic. You couldn't evict anybody. It's still difficult, but we have been successful in working with the tenants, doing some cash programs that we have for them to help them relocate right away. And that has been successful. So whatever the estate needs, we can arrange. We've probably done it already, and we just kind of rinse and repeat.
Yeah, that's great to hear. 'Cause I know we get those questions quite a bit is, how do I do this, especially when there's a family member who lives in the house and they have to have some kind of relocation in their
Yes.
process. Awesome. So again, just to recap, we work with realtors just like Gary, and we highly recommend Gary. We've been really pleased with how they handle our customers. And so for anybody who's going through probate or is thinking about probate, and you essentially need to sell real estate, please contact us. We'll tell you exactly what you need to do for the probate process. We'll refer you to a realtor like Gary in Northern California. He's been our #1 referral source. And we're just super pleased to have you on board and looking forward to have both of us work with people who are watching this video now. So we'll put a link where you can contact us, free consultation. We'll tell you everything you need to do about probate. You can tell us about the case and whether or not you may need or not need an attorney. As we discussed earlier, in California, no need by law for an attorney. However, we do recommend that people think about it, simply because sometimes the court may not issue full authority if there is no attorney involved. And we have a flat fee, $5,000 California probate attorney process, unlike the percentage that typical attorneys charge. So we're available essentially Monday through Friday, 8 a.m. through 9 p.m. Eastern time. And then we do have Saturday hours, 10 to 4 Eastern. And so for people on the West Coast, we make sure we're available on your time zones as well. So Gary, we look forward to our next deal together, and we'll be in touch.
Fantastic. One final comment I'd like to make. Your service is so great, especially with prices in Northern California. $1 million estate, $23,000 estate attorney fee. Even if the estate needed attorney services for you guys, it's only a $5,000 flat fee. That is fantastic. A lot of times we will pick up EZ-Probate's costs for the estate if they're going to sell the property. So there's some great benefits. First step is always EZ-Probate with Byron. See what they're going to be able to do for you. And then once you're in that process, if you want to talk about the real estate, then Byron will connect you with us, and we'll work together for a successful close and then final distribution. So Byron, thank you. We appreciate your service. I wish I would have had this 30 years ago, but we're looking for great things to help these estates here in California. Thank you so much.
Awesome. All right. You have a great day.
You too. Bye-bye.